what this actually looks like.
Oh, because exactly, because I think that all these concepts are great, but it's even greater when you can put it into a family law example.
Yep, and it doesn't have to, this could be a civil lawsuit.
Yeah.
But like I said, for me, it's just
Yeah.
because this makes intuitive sense to me because I've been doing this for so long, we're going to use the family law example.
Right.
So we're going to start, Eve and Adam are married.
Right.
Eve wants to divorce Adam. Okay, so now how does this work in when you're talking about pleadings, facts, and evidence?
Right.
So in order to claim a divorce in Ontario, Eve would complete a Form 8A application for divorce. This is a form that's specified under the family law rules, which is a piece of legislation. But the divorce itself is governed under the Divorce Act of Canada. So the Divorce Act applies all across Canada. The procedural rules for how you do a divorce in any province is actually covered by provincial legislation, but we're in Ontario. So she's bringing an application for divorce. The family law rules in Ontario say if you need a divorce, this is the form you use to ask for the divorce. So the form is actually set up so people don't have to think for themselves. What is the law that I have to plead to say I'm entitled to get a divorce? And then what are the material facts that I need to prove in order for the court to grant me the divorce? All of that is set up on the template of the application for divorce. So the template, once she's gone through and completed it all, meets all the requirements for what the law is that's being pled, what the facts are that support why the court should grant her divorce, and also provides the evidence to prove those facts. And the pleading is the Form 8 application for divorce, and it contains all this stuff. Now, again, keep in mind, I've really dumbed this down and kept it as simple as possible. So we're saying these people have no kids, they've got no property, they're just married, neither one is claiming support from the other, they both work, they have similar incomes. So the only thing Eve is asking for is a divorce. She doesn't want to be married to this guy anymore. She wants Adam out of the picture. So this is the factual framework that we're looking at. So let's go to the next slide.
Before we, just a very quick question. For this Form 8A, which is a pleading, do you have to get a sworn at a commissioner when you're filling that out? No?
It is, okay, remember I said affidavits need to be sworn.
I remember you said that.
Affidavits are statements of fact and evidence.
Right, so that has
this is a pleading.
A pleading, so this doesn't have to be
pleading. You have to get your application issued, but you don't have to swear it under oath. Because there's a lot of stuff in your application that that aren't necessarily facts that you're swearing to. You're pleading the law. You're setting out what the material facts are, but you're saying these are the facts. Right. But you don't have to swear to those facts yet. So we'll talk about that later.
Very interesting distinction. Okay, so here's a little bit more detail about your Form 8.
Yeah, so here we are. So we're with this whole discussion started about pleadings. Right. In a divorce, the pleadings that start a divorce case is the Form 8 application.
Right.
The form sets out what is the relief you're asking for.
Right.
And what Eve is asking for is a divorce from Adam.
Right.
She's not asking for anything else. She completed the application. She got it issued by the court, so a court file was opened on it. He was served with the application for divorce, and in the first case scenario, we're saying he's never filed anything in response. Right. Okay.
Okay. Yeah.
So in the pleadings, her application, the application, when you go through it, it actually says this is a proceeding that is brought under the Divorce Act, which is the Revised Statutes of Canada, 1985, Second Supplement, Chapter 3, and she's also pleading the family law rules, Ontario Regulation 11499, which says if you want to get a divorce in Ontario, this is the form that you've got to use. Mm-hmm. And the Divorce Act also sets out what the requirements are to get a divorce. And those depend on the facts. So once she's pleaded the law, she's saying the Divorce Act tells me I'm entitled to get a divorce if I meet the requirements.
Right.
I'm using the right process and the forms that are required under the family law rules.
Yep.
Then the form walks through what are the material facts that she has to prove in order to get the divorce.
Right.
And that's what all this stuff is when you walk through the form itself. It's their family history, their relationship dates. Did they live together before they got married? Mm-hmm. If they got married, what is the date of marriage? And any other important facts supporting the claim. Now, to do that again, you've got to go back to the law that was pled. The prerequisites for getting a divorce in Canada, or in particular in Ontario, is first of all, you have to be legally married. You can't get a divorce unless you're actually married.
Mhm.
The second thing is that in order to bring a divorce in Ontario, you have to, either you or your ex one of you has to have lived in Ontario for at least the last year, a full year, before you can start a divorce in Ontario.
Mhm.
The third thing to get a divorce, under the Divorce Act, you have to establish one of the grounds. Why are you entitled to divorce? And the three grounds are that the other party has treated you with mental or physical cruelty of such a type as to render continued cohabitation impossible. But the more common one is actually that the parties have lived separate and apart for a year.
Mhm.
And that's called the no fault ground, because it doesn't matter why the relationship broke down. The Divorce Act says once you've lived separate and apart for a year, doesn't matter why you separated, either one of you can apply for a divorce.
Right.
But you have to do the divorce in the province where either you or the other party resides, and either you or the other party has to have been in that province for at least a year.
Right.
So those are all based on facts. So you're saying I meet the requirements under the Divorce Act and the family law rules based on the following facts. Those are the material facts. Those are the things you have to prove and confirm to the court that these facts exist to give you the divorce. So for example, you are saying we are legally married.
Mhm.
This was our date of marriage. This was our date of separation. This is the date today. We have been living separate and apart for a year. Therefore, I'm entitled to my divorce.
All right. That sounds
So
good.
that's why those are the material facts that have to be pleaded. Now, when you do actually look at the Form 8, there's all kinds of other issues that come up. There could be issues of spousal support, child support, division of property, parenting.
Right.
But like I said, and the same kind of rules apply to them all. For everything that you are asking the court to give you, there are facts you have to set out in the application to support why the court should give you what you're asking for. Okay?
Right.
But we're keeping it simple. All Eve is asking for is a divorce. So in her material facts, she's saying, yep, we are legally married. Yep, this is when we separated. And yep, I'm entitled to my divorce. So let's go on to the next slide.
Yes.
Now,
Yes.
evidence.
Mhm.
So now we've just talked about what the pleadings are. It's the law and the material facts.
Right.
In order to get a divorce, the material facts are: one, Adam and I are legally married. The evidence to support the fact you're legally married is you file a copy of the marriage certificate, which proves that you are legally married. Then, to establish that you've actually been living separate and apart for a year and that you're resident in Ontario, what Eve would do is she would do an affidavit. It's a Form 36 affidavit for divorce. And it's a sworn affidavit. And this, again, the Form 36 is another template form from Eve where she is swearing under oath that the material facts that she pleaded in her application for divorce are correct. And she's providing the evidence in her affidavit to support the material facts. One of the material facts is that she is saying now, when she's doing her affidavit, is saying, I did my application. All I asked for was a divorce. I set out our date of marriage. I set out our date of separation. It was over a year ago. I've served Adam with the application for divorce, and he has filed nothing in response. So generally, what the courts do, if you've served documents on somebody and they don't respond to it, the court says they're deeming you to have agreed. Because if you're not disputing what's claimed, you won't have to file anything. So the court will proceed on the basis that what was filed in the application is true and correct. And Eve is saying, I made all these facts. Adam didn't respond. He's deemed to admit that all these facts are true. He's accepted all my evidence. The court has accepted my evidence. So now I just want my divorce judgment. So the last piece of evidence is the Form 6 affidavit of service, which is another sworn affidavit that just basically confirms that she is swearing under oath that, yes, she did serve Adam with the application for divorce. So he knows about it. He knows what she's asking for. He knows what material facts she's claiming. He's not disputing any of it. So she can go ahead and get her divorce on a default basis. Okay?
Yep.
Where can things go wrong?
I think we're going to move on to the next slide. All right, so the scenario you just explained was if Adam didn't respond, but now let's talk about what if Adam. Okay, wait.
Eve's perfect world, the last slide would have been what happened.
Right.
But this is why we have lawsuits and why we have judges and why we go to court. So so again, it confirms that Adam didn't serve and file responding pleadings. So once he served with the application, If he disagrees with what is being asked for, he has to serve and file an answer. And in a divorce proceeding in Ontario, it's a Form 10 answer. Once he's served with the divorce application, he has 30 days in which to file an answer. And if he doesn't file an answer, he's deemed to have accepted the facts pled by Eve, and he's not contesting her request for divorce, and she will get her divorce on an uncontested basis.
Right.
But what happens if Adam disputes it? So let's move to this scenario.